Our first speaker is Silvia Benussi. So thank you so much, Silvia, for coming. Silvia Benussi is the professor or a professor of the history of political institutions at the University of Cagliari, Italy. She works on the presence of women in parliaments and local administrations in Italy and abroad, and is currently studying institutional language in Italy and Spain. She's a member of Tertulia Feminista Les Comadres, Gijón, Spain.
I chose this title, Between a Rock and a Hard Place, because women's rights in Italy currently face two challenges. The threat posed by the government that took office in October 2022, which is supported by a coalition of right-wing parties on the one hand, and on the other hand, the fact that the left-wing parties in opposition are promoting policies that are also a threat to women's rights. What are the actors at play? The coalition that won the elections in September 2022 is made up of several parties, the most important of which are now Fratelli d'Italia, which is the party that had the most support in the election under the leadership of Giorgia Meloni, now president of the Council of Ministers, and La Lega. There are minor parties as well, and I will not dwell on them. Forza Italia, well, is not exactly a minor party, but I will dwell on Fratelli d'Italia and La Lega. Both are recently formed parties, but they have previous roots. La Lega was born 35 years ago as a party for the independence of a part of northern Italy. However, in recent years, this approach has radically changed. In fact, it has made Italianism, especially as opposed to immigration, one of its fundamental political themes. We can call it a right-wing populist party. Fratelli d'Italia is a party born in 2012, but it follows the tradition of previous parties that were heirs of fascism. The Italian constitution prohibits the reconstitution of the fascist party. However, since the birth of the Democratic Republic, there has been parties which gathered the political identity of those who felt nostalgic for fascism. Fratelli d'Italia, so, is a nationalist and conservative party. On the other hand, we have the opposition consisting of a center-left coalition of several parties and more fragmented within itself. The main left-wing party is the Partito Democratico, born in 2007 from the union between the I Democratici di Sinistra and La Margherita. The I Democratici di Sinistra had roots in the dissolved Italian Communist Party, but they had already moved towards reformist positions in the 1990s, while La Margherita had its roots in left-wing Catholicism. Now, in addition to the Partito Democratico, which has these two souls, one in social democracy and the other in leftist Catholicism, the center-left opposition comprises several other minor parties. The leader of the Democratic Party is also a woman, Elise Schlein. Outside this coalition, there was another electoral list, Azione Italia Viva, a centrist one, which brings together two small parties with their origins on the left. Finally, a party that has gained support outside of the left-right identity is the Movimento 5 Stelle, which was born in 2009 and is strongly populist. It presents itself as a movement that rose out of indignation against the corruption and inadequacy of the political class. In the past, has allied itself with both the right and the left. This premise was necessary to get to the point that interests us most, to see how none of these forces guarantees women's rights. None of these political parties has a good program or a good will to protect women's rights, nor has a political culture that recognizes the oppression that women suffer based on their sex. Actually, all political parties represent a real danger to women's rights. For the sake of time, I will dwell only on a few issues that I consider especially important. The issue that has caused the most stir is the new law about surrogacy. In October 2024, Italian Parliament passed the law extending abroad the ban on surrogacy, which has existed in Italy since 2004. This law was strongly desired by the Giorgia Meloni government, above all by the Minister for the Family, Birth and Equal Opportunities, Eugenia Roccella, who was part of the feminist movement in the 1970s and then moved towards conservative positions. The spirit of the law undoubtedly responds to a traditional view of the family, women and motherhood. However, let's read the bill's accompanying report. We can see that it includes correctly, I leave to the side some errors, for example, the reference to India, it includes a denunciation of this practice of the surrogacy as, quote, an execrable example of the commercialization of the female body and of the children who are born through such practices, who are treated like commodities. And so it defines surrogacy as a practice contrary to the international evolution of the recognition of children's rights and women's rights. On the other hand, if we read the minority report, the report of the leftist parties against the law, albeit with exceptions, it leaves us appalled. This minority report that also reflects the positions held by left-wing intellectuals and women who self-identify as feminists in the public debate is based on a manipulation of the principle of women's freedom of self-determination. It calls into question women's right to choose about their bodies by extracting it from the objective circumstances of economic vulnerability that determine women's choice to lend themselves to surrogacy. It speaks of guarantees that have already been shown to be fallacious where there is a commercial interest involving the exploitation of the body, and above all, this minority leftist report confuses free determination with the cession of women's rights to control their bodies to a third party. This stance that was reivindicated as a leftist stance in the parliament and from intellectual and self-identified feminist left outside the parliament fits perfectly into the quote, myth of free choice, as defined by Spanish philosopher Ana de Miguel, a myth that, ignoring power structures, cover exploitation with a call to freedom. Another issue addressed by the Meloni government is May violence against women. This March, the government introduced a bill on feminicide. At the moment, it's under scrutiny of the Justice Committee of the Senate. Let us start with that. The Italian Constitution of 1948 recognizes the equality of the sexes, but this did not prevent legal regulations discriminating against women for more than 30 years. For example, until the end of the 60s, Italian penal code stipulated that adultery was a crime and punished women and men differently. Until 1975, Italian civil law, the family law in it, enshrined the superiority of men. Until 1981, the penal code included penalties that were reduced in the case of honor killings. Despite this, the narrative built around the Italian legal system is that of a subject of a law, concept that derived from the French Revolution, that is not sexed. This idea has already been challenged precisely because it does not consider the fundamental power structures between men and women. The point is that the neutral legal subject was vindicated when, once formal equality was achieved in 1980s, attempts started to sexualize this subject in order to counter discrimination against women. For example, when in the mid-1990s, new electoral laws were introduced to favor women's presence in political representation, the Constitutional Court rejected those laws, saying that it was not permissible to make the need for balance explicit. It was necessary to amend the Constitution in the early 2000s and thus provide for a constitutional obligation to promote equal access to public office for women, so that the electoral equality laws could be enacted. In addition, this must be done using a language that is, in any case, neutral. For example, I quote just an example, neither sex may be on the electoral list for more than percentage. Thus, without making explicit the fact that it is the female sex that is constantly underrepresented. Again, in 2013, a law was enacted that was described as a law on gender-based violence. It has in the title gender-based violence, but which really is more alone domestic violence, since it does not make explicit in the articles the fact that the aggressor is a man and the victim a woman, differently from what the law about gender-based violence of Spain of 2004 does. Consequently, a bill like the one prepared by the Meloni government, this bill about feminicide, which not only names women and provides for feminicide as a crime in its own right, but also recognizes feminicide as a form of discrimination against women, would be a breakthrough in our legal system. However, albeit we can positively assess this bill, at least in its basic meaning, I will not dwell on some points that are, in my opinion, open to criticism, there are other worrying proposals. There is another bill currently being examined by the Senate Justice Committee that is very worrying, that not only demonstrates the prejudice against women of the current majority, the current right side majority, but also hinders the prevention of gender-based violence. It is a bill that would impose a mandatory 50-50 sharing of child custody between parents in case of separation or divorce. What is the problem? The child is treated as a co-owned object without taking into account his or her need for a stable environment in which to live, and situations of gender-based violence neither are taken into account. Father denounced or even convicted of gender-based violence would then, despite this, be entitled to share custody of his children with his female partner or ex-partner. This is already happening in Italy due to a law that already proposed this model in 2006, a model which now will be tightened by this new bill. Children are used by violent men as a weapon against the victims. This new bill would even provide for a mandatory family mediation, even if mediation is explicitly prohibited by Article 48 of the Istanbul Convention because it is detrimental to the women victims of violence, of gender-based violence. It will provide for giving the child to one parent if the other does not comply with the terms of joint custody or quote, artfully creates obstacles, and this is a way of introducing into our legal system a recognition of parental alienation syndrome, which is already used in Italian courts to take children away from their mothers, even though it has been delegitimized several times by the Supreme Court of Cassation. We cannot think of acting politically against feminicide on the one hand, and on the other hand, approve a law that allows violent men to blackmail and harm their female partners through the abduction of their children, undermining the prevention of gender-based violence from the very foundation. The last issue that I address is the subject of transgenderism. The Italian law on the subject, which dates to 1982, does not speak of gender but sex. What changes in documents in Italy is the sex. That means that the person is, to all intents and purposes, legally the sex that is recognized by the identity document. The 1982 law spoke of rectification, whereby a person is given a different sex, legal sex, from that stated in the birth certificate. But that could only happen in the past as a result of intervening changes in his or her sexual characteristics. The change of the sex in ID required, and still requires, a decision of a court. The courts allowed the transition in the past, only following a body change. One important thing, the 1982 law did not specify the reason for permitting this sex adjustment, nor did it mention the root motivation for requesting this change. Now, the Constitutional Court, in a decision of 2015, that contains a reference to another sentence of 1985. In this case, the case of 2015, it was a case of a female to male transition, ruled that the 1982 law is constitutional, but beware. It says that surgical treatment constitutes only a possible instrument, not a mandatory one. So, According to the 2015 decision, what is the requirement for the court to recognize a sex change? The requirement is a quote, path of transition which must cover the psychological, behavioral, and physical aspects that combine to make up the gender identity. In 2017, the Constitutional Court told that self-ID can't be introduced at the moment. The problem with this ruling of 2015 that talks about the path of transition, which must cover the psychological, behavioral, and physical aspect combined to make up the gender identity. The problem is that not only it recognizes gender identity, but links it to constitutionally protected rights. This ruling expresses highly problematic concepts. Sex and gender are confused and used interchangeably. The ruling speaks of people who have adopted the behavior of the other sex. It affirms the conception of sex as a complex part of the personality determined by a set of factors, the balance of which must be sought, privileging the dominant ones. We are thus in full defense of sexist stereotypes and even of the idea that sex is a spectrum measurable in greater or lesser femininity and masculinity. Thus, the ruling enshrines in our legal system the idea that being a woman or a man corresponds to a series of stereotypes and establishes that legal sex change must take place according to the degree of adherence to femininity or masculinity. Must take place in case of a request. Furthermore, there is a total and complete indifference to the asymmetry in which women and men live. The issue, by this ruling of 2015, is treated as if the male-to-female or female-to-male transition had the same social consequences. The ruling only takes into account the desire of the individual, without evaluating the impact, for example, on equality policies, which in Italy are extremely poor, but which are nevertheless affected by this choice. It is true that the requirement of a court ruling makes the transition less arbitrary than self-ID, and as I said, excluded by the Constitutional Court in 2017, and reduces the dimension of the phenomenon compared to other countries. However, this does not change the fact that in this way, deeply sexist and patriarchy-denying principles have become entrenched in our legal system. Above all, the overlapping of sex and gender is appalling, and as it is also the total disavowal of gender as an instrument of oppression, and its recognition instead as an identity. Furthermore, abuses exist and are evident. For example, we have, I give only an example, the participation in the Paris Paralympic Games of an Italian male athlete legally recognized as a woman, thus depriving female athletes of opportunities. On a positive note, we must recall that in October 2021, the Italian Senate blocked the so-called DDL Zan, a bill strongly supported by the Partito Democratico and the larger part of the left, not only the left, for example, also was supported by Movimento 5 Stelle, and it was entitled the title, Measures to Prevent and Combat Discrimination and Violence on Grounds of Sex, Gender, Sexual Orientation, Gender Identity, and Disability. What was the problem with this bill? Basically two. The first is that it would have reinforced a strongly sexist and misogynistic concept in our legal system. For example, again, gender is defined as the, quote, outward manifestation of a person that conforms to or contrasts with social expectation related to sex, without taking into account the political significance it has as an instrument of oppression of women and the asymmetry that exists between women and men concerning gender. Everything is traced back to individual feeling, to an identity perceived and manifested by the individual. The second problem is that the bill would have provided for criminal conviction for, quote, acts of discrimination also related to gender identity, and would have established the prohibition of, I quote, any organization, association, movement, or group whose aims include incitement to discrimination. End quote. It is crystal clear how easily it would have been to brand radical feminism as discriminatory and to bring it to account under the criminal measures proposed by the law for not accepting transidentified males as women. Furthermore, the Article 4 of this bill apparently saved the freedom of expression, but not if the opinion, I quote, were suitable to determine the concrete danger of the perpetration of discriminatory acts. Again, if considering a transidentified male as a man is assessed as discriminatory, the guarantees would have been lost. In conclusion, we see that we face two problems. The first is that of a country where the legal system does not sufficiently take into account the historical oppression of women, hiding behind the neutrality of the legal subject and the purely formal concept of equality, and even protecting sexist stereotypes. On the other hand, the current presence of political forces that do not guarantee women's rights they are the right that beyond some specific issues such as surrogacy remains linked to a conception of the family that favors the power of father and husband even in context of violence. I am to speak of abortion because at the moment is not a hot topic, but the rights doesn't favor the exercise of the right to abortion. And the left has adopted a postmodern vision based on the myth of free choice, and which denies the oppression of women as a sexual class. That doesn't mean that we should renounce to sensitive interaction with the institution. Talk with the institution, try to cooperate, work with the institution, and push the institution to our side, regardless of the political force governing them at any given time. But we can't say that we have really effort that is really in favor of women's rights, above all, women sex-based rights. Thank you very much.
Wow, thank you so much, Silvia. That was incredibly comprehensive roundup in just 25 minutes or 20 minutes of the situation in Italy and also the political situation, the parties and the law. And then it was so interesting you going into how it's happening and how it's playing out. I really thought it was helpful, some of the concepts you were sharing with us, like the asymmetry of transition and the deeply sexist and patriarchy denying concepts, and then protecting sexist stereotypes. And then another phrase you used, which was amazing, was great, was the denying the oppression of women as a sex class. If it's possible to share the words of your speech with us, I would really like to put them on our website, because I think that a lot of the phrases are very clear. They come very well in English, and they really clarify the problem we have now, where even, I mean, in Britain, now that they have said sex is biological, we still have all of these postmodern equality-based laws and sort of norms in our institutions which deny the oppression of women as a sex class, as you say. We don't have any questions at the moment, but I suppose I would say, can I ask just one, and then we'll come back at the end? What is the resistance at the moment to these gender identity ideologies, or this postmodern viewpoint, equality viewpoint?
There is a little resistance. I say little because radical feminists are not many in Italy. We have a radical feminist, but we had some success. For example, the parliament some months ago, gave the authority for the protection of the children to Marina Terragni, that is a radical feminist, and she can look at try to protect in a better way the rights of children, about all of from transitions and even in case of this bill of shared custody. She already spoke to the parliament about this issue. There are also some organizations that are rooted, for example, in the socialist and communist past that are skeptical of transgenderism, but the feminism in the streets, the marches, for example, are governed by associations that are more trans feminist. So there is a mass or a huge quantity of women and girls that recognize themselves in trans feminism. And this is a problem because they are very present in March, for example, the March for the International Women's Day. So the resistance is a little distant, but that has a good capacity to resonate itself with institution, as in the case of the nomination to the Children's Authority of Marina Terragni.